Okay, let's go to chapter 9. Chapter 9 deals with title transfer and records. We're talking about ownership and transferring property. Now, the term title has three meanings. You got highlight, put X by number 1, 2, and 3. Number 1, title is a way of referring to the ownership. Number 2, title to real estate means the right of ownership or actual ownership of the land, represents the owner's bundle of legal rights. Remember, deep C that we talked about a long time ago. And number 3, title serves as evidence of that ownership. Now, we're going to talk about deeds. Well, let me talk about statute of frauds. I'm going to talk more about this later, but highlight put X by statute of frauds. Statute of frauds are state laws to prevent fraud. Anything that deals with real estate must be in writing. I'm going to talk more about this in chapter 12 when we get into contract. So anything that deals with real estate must be in writing. If I said to all of you, and there's 23 of you out there right now, students, if I said to anybody, hey, I'll give you $1 million for your home. You got 23 witnesses out there. Take me to court. You lose. Unless it's in writing, it doesn't mean anything at all. It must be in writing. That's statute of frauds. Anything that deals with real estate must be in writing. Otherwise, it's not enforceable in court. Verbal means nothing in real estate. As I said, I'll talk more about this in chapter 12, contracts. Now, requirements for valid deed. The minimum requirements for a deed, in order for a deed to be valid here in the state of Illinois, you need these, you could go over these bullets right here. I'm going to mention all these right now. Before I do, there's something I want to do. I want to help you out with some terms. There's some terms for you. I want to talk about what we call the OR E rule. The OR is the give or. The EE is the receivee. So a lot of these terms I'm going to be talking about. For example, the lessor is the owner of the property who gives the lease to the property to the tenant who receives it. That's why they're called the lessee. The vendor is the owner of the property who sells it to the buyer, the one that receives it, called the vendee. The optionor is the person that gives the option to the one who receives it, optionee. The grantor is the one that gives the deed to the new buyer, called the grantee, the one that receives the deed. Now, maybe this little trick might help you remembering the OR-E rule. I think of the employer as the one that gives the job to the employee, the one that receives the job. That might help you remember the OR-E rule. Now, saying that, that's true in every case except for one. There's one that's just the opposite. And it's a little complicated to explain why. So I don't want to explain why, but I'm going to give you a way to remember it. We have something called a mortgagor, and we have something called a mortgagee. And this is the only one that's opposite, and it's really complicated to why it's opposite, but I'm going to give you a way to remember this one, as opposed to everything else. The mortgagor is the buyer of the property, the one that borrows the money. The mortgagee is the lender, the bank. And it's the only one that's opposite. And maybe to help you remember this, the mortgagor is the buyer of the property. The mortgagee is the bank, the lender. Or remember this, the mortgagee is the one that has all of this money, which is always the bank. That might help you. The one and only, that's just the opposite of everything we're talking about. Okay? That's how I do that. Now, okay, I'm going to go over these real quickly because I am going to get into details about these. The grantor, they must have legal capacity to execute or sign a deed. The grantee must be named with reasonable certainty. As I said, I'm going to get into detail in the next minute or two. You need a receipt of consideration, what they pay for the property. You need a granting clause, identifies the type of deed that they're receiving. You need an accurate legal description of the property, that we went over legal descriptions. A house address by itself is not sufficient. Any exceptions or reservations, these are private restrictions imposed by the seller to the new buyer. The only one that signs the deed is the grantor. And what transfers property is when the deed is delivered to and accepted by the grantee. That's what transfers property. So let's talk about all these one at a time. Let's go on to the next page. Highlight, put an X where it says grantor. A grantor must be of lawful age, at least 18 years old. A minor cannot sell property. A minor can buy property, but they cannot sell property. You have to be 18 years old to sell property. The next paragraph, the first 7 words, highlight, put an X by it. The grantor must be of sound mind. They can't be mentally challenged. They can't be under the influence of drugs or alcohol. They must be a sound mind. I have a question. How can a minor buy property? A minor is allowed to buy property, but then I'm going to talk about it. Just stay with me. I'm going to explain it to you in a moment, okay? I'll tell you how they could buy property. Make sure you're fully covered on that. Now, the next paragraph, highlight, put an X by that. The grantor's name must be spelled correctly and consistently throughout the deed. Now, the owner, the grantor, their name is mentioned several times in a deed, and they have to use their legal name. Let's say their first name is James. They got to go with James the whole time because they can't call him James one time and next line they call him Jimmy or Jimbo or Jim. They have to use the correct spelling and the legal name throughout the entire deed. The grantee, highlight, put an X by that one. To be valid, a deed must name a grantee. The grantee must be specifically named so they know to whom the property is being conveyed. Now, I'm going to explain a couple of things to you, and you can figure out who wrote the law. A man who is single is called a bachelor. A man who was married but now divorced is considered a bachelor. Now, a woman who was married but now divorced, they had to identify that person as a woman who was once married but is now divorced. Now, a woman that's never been married, and it doesn't matter how old you are, a woman that's never been married, the term they use for them is called spinster. Now, a lot of females don't like that term spinster to identify them as being single, because spinster was used in a lot of those old fairy tales and fables and stuff like that. And a lot of times the spinster was described like some old hag who couldn't get a guy or something like that. I remember I had this young woman. She was around 20 years old. Her father passed away, and she inherited father's home, and she wanted to sell it. So I sold the property, and then they identified her as a spinster. She was 20 years old and never been married. She says, I don't like that word. You got to take that word out. It says we can't. That's what you are. She got mad. First of all, she started crying at the closing. Crying to make the lawyers remove it. Then she got upset and she started with a bunch of FUs right at the closing to her attorney. Guess what? That did not remove the word spinster. That's what you are. That's it. I mean, that's the law. Skip down a couple paragraphs, 3 paragraphs where it says consideration. Highlight, put an X by that. A deed must have consideration, something of value. Now, on the deed itself, they don't have to say exactly what you paid for the home. But those of you that own any property here in Illinois, I tell you what it says how much you paid for your property. $10. They all say the same thing. Anyone that buys a home on the deed that says you paid $10, they say, because they have to have a dollar amount. They don't have to say exactly what you paid for it, but they have some type of dollar amount. Now, they will say that you paid $10 and other valuable goods in consideration. Granting clause, put an X by that one. The granting clause identifies the type of deed they're going to receive, which I'll talk about in just a few more minutes. It says I quit claim, I grant, I bargain and sell, I warrant the property, identifies the type of deed that you're giving to the grantee. 2 paragraphs down, legal description of the property. On the deed itself and all legal documents, deeds, titles, surveys. It's going to be the north half of the southwest quarter, the northwest quarter, all that stuff that we went through. A house address is not sufficient for any legal document. Exceptions and reservations, put an X by that one. Any private restrictions imposed by the owner of the property to the new buyer has to be stated on the deed itself. Let's go to the next page. Signature of the grantor. I want you to remember this, put an X by that line. The only one that signs the deed is the grantor only. That's the only one that signs the deed. 2 paragraphs down where it says acknowledgement, notarization. The next 2 paragraphs after that, highlight, put an X by. Now, here's where you make sure you know what I'm telling you. A deed in Illinois does not need to be recorded to be valid. A deed does not need to be recorded to be valid. But if you go, and a deed should be recorded. And if you're going to record a deed, then it must be acknowledged or notarized. But I want to repeat that. I want to make sure you understand me. By law in Illinois, a deed does not need to be recorded in order to be valid. A deed should be recorded. And if it is going to be recorded, then it must be acknowledged or notarized, attesting that your signature is genuine. The next paragraph, delivery and acceptance, highlight, put an X by that one. What transfers property when a deed is delivered to and accepted by the grantee? The grantee does not sign the deed. The only one that signs the deed is the grantor only. What transfers property? I have a deed here in my hand. I took this deed, I handed it to one of you, and you accepted it from me. Now you're the owner. That's all it took for you to be the owner. Deed needs to be delivered by the grantor and accepted by the grantee. Grantee does not sign the deed. Now, let's talk about different types of deed. Okay, the most common type of deed forms. Highlight, put an X by general warranty deed. Highlight, put an X by the second bullet, special warranty deed. And highlight, put an X by the 4th bullet, quitclaim deed. I'm only going to talk about 3 deeds. General warranty deed, special warranty deed, quitclaim deed. That's the only 3 I need you to know about. So, let's go to this next paragraph. General warranty deed. General warranty deed is the most common type of deed used in this country. It's also called a warranty deed. Now, the general warranty deed is the only one that has 5 covenants. There's your 5 covenants. I'd like you to highlight all 5 covenants, those 5 bullets, but put an X by the first one. If any of them will show up, I would say the first one, the covenant of sazon. So let me go over these 5 covenants. This is under the general warranty deed or the warranty deed. The first one is called the covenant of sazon. Covenant of sazon means that he or she owns a property and has a right to sell or convey title to that property. The next bullet is covenant against encumbrances. The grantor warrants that the property is free of any liens or encumbrances except for those specifically stated in the deed. Next bullet, covenant of quiet enjoyment. Grantor guarantees that the grantee's title will be good against third parties who might bring court action to establish superior title to the property. Covenant of further assurance. Grantor promise to obtain and deliver any instrument needed to make sure that the title is good. And then covenant of warranty forever. Grantor promise to compensate the grantee if the title fails anytime in the future. The general warranty deed or the warranty deed, again, is the most common type of deed that exists. It creates the greatest liability on a grantor, offers the greatest protection to the grantee. It's the only one with the 5 covenants. Now, if I give you a general warranty deed, because of these 5 covenants, what I'm telling you is that I warrant and guarantee this property during the time I owned it. I warrant and guarantee this property even before I owned it. And I warrant and guarantee this property even after I own it, which means if anyone has any claim to this property whatsoever, I will spend my money to defend your right to this property. And I will do this forever and ever and ever and ever and ever is the best type of deed to get. Someone has a question. Difference between a deed and a mortgage. A deed is a piece of paper that transfers ownership. A mortgage is the loan on the property, getting the money to buy that property. It's the loan that you have to pay back. Major difference on those, okay? And that the deed is just a piece of paper that transfers the ownership of the property. The mortgage is the loan that you have on that property. Now, let's go on to skip that next paragraph. Go to the paragraph that says special warranty deed. Highlight, put an X by that one. Highlight, put an X by number 1 and 2. I have another question before I go over that one. Question is, I can't read the question here. What's the difference between title and a deed? Oh, that's a good question. I'm actually going to talk about it in this chapter. Title is proof of ownership. Title means I own this property, I have a right to sell it. The deed is a document that transfers that ownership. The deed is just a piece of paper that transfers it. Proof of ownership is title. Now, okay, special warranty deed. Only has 2 basic warranties, and I told you highlight, put X by number 1 and 2. Warranty that the grantor received title. 2, warranty that the property was not encumbered during the time the grantor held title, except as otherwise noted in the deed. So, special warranty deed only warrants a property during the time it was in a grantor's possession. They are not responsible before it came in their possession. They're not responsible after it left their possession. But let me give you a couple of examples of who will issue a special warranty deed. Let's say you had a relative of yours that died. You're the executor of their estate, and you have to dispose of that property. It took you 6 months to get rid of that property. You will probably give a special warranty deed that during the 6 months, this property you held in your possession, you did not encumber the property. You're not responsible before it came in your possession. You're not responsible once it leaves your possession. Let's say a court takes over a property, like in a foreclosure or a bankruptcy, and then the bank sells it. The court will probably issue a special warranty deed that during the time, how many ever weeks the courts held onto the property, the courts did not encumber the property. They are not responsible before it came in their possession. They're not responsible after it left their possession. Only during the time that they held onto the property, they did not encumber the property. Now, let's skip down to quitclaim deed. And there's 3 paragraphs on quitclaim deed. Before I go into that, someone has a question. How long does someone have to put a lien on a deed? You don't put a lien on a deed, you put a lien on a property. See, liens involve money. The deed is a document, so you put a lien on the property itself. That will prevent the property from being transferred until that lien has been removed. Like a mortgage lien, a tax lien, a lawsuit lien. You can put a lien on there anytime. Put a lien on it now. Anytime you can put a lien on a property. Anyone can put a lien on a property at any time. Now, quitclaim deed. Make sure you highlight, put X by these 3 paragraphs. Now, first of all, the quitclaim deed has no warranties whatsoever. None. Quitclaim deed is often used to clear the cloud on title, which I'm going to talk about later on in this chapter. Now, a lot of times when couples get divorced, one spouse will quitclaim their share of the property to the other spouse. And when they do that, what they're telling them, okay, whatever interest I have, I'm not going to quitclaim to you. In other words, I don't ever want to see or hear from you ever again. That's what it means. Now, the quitclaim deed has a little nickname in the profession. Let me clear my board. Quitclaim deed. Let me write it down. Quitclaim deed has a little nickname because it has no warranties whatsoever. Whatever interest I have, you have. If I have nothing, you have nothing. They call it the don't come back to me deed. Don't come back to me deed. Now, let's say, let me give you a crazy example. Let's say you and I enter into a contract. I agree to sell to you Navy Pier. I'm going to sell you Navy Pier. Well, somehow you got the money. I don't know how, but you raise the money. We get to the closing. What I will give you, the deed, I'll give you a quitclaim deed to Navy Pier because I don't own Navy Pier. But the quitclaim deed states this. If I did own Navy Pier, you now own Navy Pier. If I don't, you don't. Don't come back to me. Now, let's go on to title transfer stamps, okay? Now, whenever real property is transferred here in the state of Illinois, I like you to highlight, put X by these 3 bullets. There's a state transfer tax, which is 50 cents for every $500 or fraction thereof. There's a county transfer tax that's 25 cents for every $500 of value or fractional part thereof. And then the total transfer taxes, both the county and the state, will be 75 cents for every $500. Are you going to get questions on transfer tax stamps? Yeah, you will. You sure will. I'm going to go over a few of these with you. Now, there are municipal taxes, but every city is different. None of them are going to be on the state exam. So let me get to my board. So there is a state transfer tax. And the state transfer tax is 50 cents for every $500 of value or any fractional part thereof. There is a county transfer tax you need to be familiar with. The county transfer tax is 25 cents for every $500 of value or any fractional part thereof. So whatever a property happens to sell for, you take the sale price of the property divided by $500, whatever the results are, you multiply it by 50 cents, and that gives you the state transfer tax. Now, to figure out the county transfer tax, you take the sale price of the property, divide it by $500, and whatever the results are, you multiply that by 25 cents, and that will give you the county transfer tax. For example, and I expect all of you to do this, for example, a property sold for $363,500. What I need you to do is take a moment and figure out what will be the county transfer taxes. Divide that number by $500, whatever the results are, you multiply it by 25 cents. Go ahead and do it. Type in your answers. I'll give you a moment to get it solved. Property sold for $365,500. I need you to figure out what will be the county transfer tax. Are you going to see this on the state exam? Yeah, you will. Yes, you will. Most of you got it right. Now, Zubar, Ahmed, let me tell you something. You're saying that the transfer tax is $45,000. So listen, Zubar, I'm going to remember your name. And if you ever run for any political office, I'm going to make sure you don't get into office because you just raised the hell out of our transfer taxes. The answer is $181.75. Don't raise our taxes. Our taxes are high enough. I'm at 181.25. Now, I want to show all of you something. Let me just actually get to my questions and clear my board. So most everyone got this correct. Very, very good. You're hearing the clicks, don't worry, I'm just clearing my board. I'm going to show you a shortcut to figure out both the state and the county transfer taxes in your head, but it might take you as long as 1 or 2 seconds. Let's say a property sold for sold for $245,000. Question is, what will be the state transfer tax? What will be the county transfer tax? Well, it's 50 cents for every $500 or $1 per thousand. All you have to do is change this comma here to a decimal point. So the state tax will be $245. The county is going to be half that amount, which come out to $122.50. This is going to be correct 100% of the time. I put 185.25. I put 181.75 is what I did. Talking about right here, 181. By the way, the state taxes on this one, $363.50. So right, Brian, it's a dollar per thousand. And by the way, this shortcut will be right 100% of the time. 100% of the time. Now, if you don't get it, then what you have to do is you take 245,000, divide that by $500, and multiply it by 50 cents, and that give you the state tax. And then you take the 245,000 divided by 500, multiplied by 25 cents to get the county transfer tax. This is a shortcut that I showed you. Will be correct 100% of the time. Now, I'm not done with this. You always have to end in increments of either $500 or $1,000. You get any odd amount. If a property sold for here, let me do a little bit erasing here. Let's say a property sold for $363,600. $363,600 has to be rounded up to the nearest 500, which means brings us up to 364,000. You always have to round up. State tax is 364. The county will be 182. You always have to round up to the nearest 500. This property here sold for, let me erase my numbers here. Let's say this one sold for $245 and $95. $245.95 becomes $245,500. Why? You always round up. You always have to round up to the nearest 500. So the state tax is $245.50. County will be $122.75. Why? You always round up to the nearest 500. Always round up to the nearest 500. Okay? So I have a question, another question for you. And you might see, some of you will see this on the screen. A property sold for $442,000 and 10 cents. A property sold for $442,000 and 10 cents. That's what the property sold for. So I need all of you to take a moment and figure out what will be the state tax and then figure out what will be the county tax. So go ahead, take a moment, figure this out. You have your answer, type it in there. So a property sold for $442,000.10. I need you to figure out the state tax, and then I need you to figure out what the county tax will be. County tax, you divide by 500, and whatever results are, you multiply by 25 cents. County tax and that. Divide that sale price by $500. Multiply whatever results are, you multiply by 25 cents, 0.25. Jamie, I'll explain your question in a moment, okay? I'll explain it to you in just one moment. Okay, so I'm looking at your questions here, your answers. And a lot of you got the right answer. And the right answer, well, let me write it down for you. State tax, well, $442,000.10 automatically becomes $442,500. So the state tax is $442.50. County is $221.25. That's what it is. Why? Because you have to round up. State law says you always round up, round up, round up. Did I say round down? Someone says, why don't I round down? It's under 500. Because the law says round up. You always round up. Round up, round up, round up, round up. You don't do anything but round up. In fact, if you want to write this down, I want to give you the 3 rules for rounding up to the nearest 500. Rule number 1, round up to the nearest 500. Rule number 2, round up to the nearest 500. Rule number 3, round up to the nearest 500. I have a question. Does anyone have any question on what I just said? Anything but rounding up to the nearest 500 is wrong. Are we okay with that? You gotta be careful. Some of you gave me the answer for both of them. You gotta be careful. On a state exam, they might ask you for the state only. They might ask you for the county. They might ask you for the transfer taxes. So you have to do both of them. Now, someone asked, so property sold for 300,000. Here, let me write it down. So make this clear to you. Someone said, what if a property sold for $300,500, say 1 penny? The taxes are going to be based on 301. Why? You round up. Goes up to 301. You always round up. Always round up. You're right. If we round down, the state's going to lose money, and the state is not going to lose money. Round up. Okay. That's the law. That's the rules. That's where you're not. There's no other way. Annette, do you understand the county transfer tax? Do you understand? Annette, I want to make sure you do. Take this first problem. Take that $364,000. Divide that by, use your calculator right now. Divide that number by $500. Should give you something like $728, I believe is what it's going to be. Then multiply that by 50 cents. That's going to give you the state, or 728. Okay. Now multiply that 728 if you want to figure out the county taxes by 0.25. Do that. You get 182. Do that on your calculator. Do it now. Wait. Take $728, multiply it by 0.25. Don't forget the decimal point. 0.25. And you get 182. You got it? That's the transfer tax on a $364,000 property. Okay. Anybody has any other questions before I go on? You're welcome. Because I'm not quite done. Let me give you another. Well, let me write that. I would write, be familiar with, I'm going to write down. Transfer taxes are always paid on the purchase price unless the buyer assumes the existing mortgage unless the buyer assumes the existing mortgage or personal property is included with the sale. Then the assumed mortgage or personal property is deducted from the purchase price and transfer taxes will be paid on the difference. So let me explain this to you. The purchase price of a property was $450,000. You're going to assume my mortgage. I owe $360,000. And you're going to assume that mortgage. Remember mortgage assumption? Mortgage assumption, you take over my mortgage payments, that's a mortgage assumption. I have equity of 90,000. So you give me my $90,000 and you assume my mortgage. So again, in the mortgage assumption, whatever my interest rate is, your interest rate's going to be the same. Whatever my monthly payments are, your monthly payments will be the same. So transfer taxes are paid on a difference. This is $90,000. The state tax will be $90. County will be half that amount, 45. Whatever the property sells for, you deduct the assumed mortgage and you pay on the difference. Let me do a personal property. I sold my property to you for 400,000. I left behind some personal property. I left let's say I left, it's not real property, home entertainment center. And the value of the home entertainment center was $12,850. So you deduct the personal property, which gives me $387,000. That transfer taxes have to be paid on. But 387,150 has to be rounded up to the nearest 500. So 387,150 becomes 387,500. State taxes 387.50. The county will be 193.75. Seller pays the state and the county transfer tax. As I said, there are municipal taxes, some paid by the buyer, some paid by the seller, some are split. But state and county, seller pays state and county transfer tax. You understand this problem I gave you? I just did. Anyone not clear on this, so I can make sure you do understand it? Okay, no questions? Not clear. Okay, Lizette, what is it that you're not 100% sure on? And I will explain it to you. Shanice is not quite sure of it either. Okay, let me do this over again, all right? Because I gotta make sure you understand that. Right here, what I wrote on here. Transfer taxes are always paid on the purchase price unless the buyer assumes the existing mortgage or personal property is included with the sale. Then the assumed mortgage or personal property is deducted from the purchase price and transfer taxes will be paid on a difference. Okay, now. Okay, the purchase price here was $450,000. I'm selling you my home for $450,000. I have a mortgage existing on it for $360,000. You're going to assume this mortgage of $360,000, okay? Which means whatever my interest rate is, your interest rate is the same. The difference between this is my equity. This $90,000 is my equity in the property. So the transfer taxes are always going to be paid on the difference. Why? Because on that $360,000, I already paid the transfer tax on that when I originally bought the property. Now I still have a big mortgage. I sold it to you. You just pay on a difference on the equity. So the state is $90. The county is going to be 45. Now let me go to the other one, and if you're still not clear, I'll explain it to you. I sold my property to you for 400,000. I left personal property behind. Personal property is not going to be taxed. I left a total personal property of $12,850 here, which means that the difference is $387,150. So I have to pay transfer taxes. The buyer has to pay, or seller has to pay transfer taxes on a $387,150. But $387,150 becomes 387,500. Why? You round up to the nearest 500. State tax is 387.50. The county's 193.75. Now, anyone not clear on this? I mean, I want you to be 100% clear. Okay, Lizette, you're right. You're good on this one. Anybody else not sure on this? You got a couple problems in the back of this chapter. Make sure you do them by Monday's class. Okay, I got one more thing. Let me do one more problem for you. Still on transfer taxes. Oh, I got to erase my board. Forgot I did that. Erase all drawings. Okay. So here's another problem for you. A property sold. Let me bring this down a little bit. A property sold for $300,000. The buyer's putting a down payment of 20% down payment. The question is, for all of you, is what will be the state transfer taxes separately, then what will be the county transfer taxes? So take a moment, figure this out. Type in your answer and give you a moment to do it. So a property sold for $300,000. Down payment that the buyer put down was 20%. He's going to finance the difference. Question is, what will be the state transfer tax? What will be the county transfer tax? Now, those of you that are out there, I want to let you know I saw this on a state exam, the same problem. So you need to figure it out. All of you. Just to let you know, this is on a state exam. When I ask these questions, I think these are very important. I wouldn't even waste the time. I'd tell you just go home and study or something, and then come back. But I'm telling you, you're going to see this on a state exam. Okay. Let me write down some of the answers some people put in. Some people have for the state 300, the county 150. Some people have 240 for the state, $240, 120. Some people have $60 and $30. Some people have 240 and 10 cents, while others have 120 05, I have 60, 50, 30, 25. So that's what I'm seeing right now. 588 county. Okay, let me tell you what the answer is. The answer is state is 300. The county is 150. Brian, you're right. They threw that down payment in there to kind of throw you off. Doesn't matter if you pay cash. It's 300 and 150 because of this. Here's what I said up here. I wrote this down. I hope you wrote it down too. Transfer taxes are always paid on a purchase price unless the buyer assumes the existing mortgage or personal property is included. There's no mortgage assumption with this problem here. There is no mortgage assumption here. Transfer taxes are always paid on a purchase price unless the buyer assumes a mortgage or personal property is involved. The state tax is 300, the county is 150. Now, if they happen to ask what are the transfer taxes, that would be both of these combined. There's a lot of trick questions. They are tricky. You've been seeing that. I got a lot more like this too. Let's go on down a little bit to get all the transfer taxes done. So let's go to page 163 near the top. Involuntary alienation. You can put X by that and make sure you understand that. Involuntary alienation is the involuntary transfer of property. You do not want to transfer your property. It could be through a bank foreclosure. It could happen through a tax sale. You did not want to sell your property, but you lost your property. Now, transfer by adverse possession. I want you to highlight, put an X by that one. The words to describe it: open, notorious, continuous, uninterrupted, hostile, and adverse to the true owner's possession. Number of years is 20 years. Now, adverse possession, also called squatter's rights. Let me get to my board. Adverse possession. It's important. It's also called squatter's rights. Now, the words to describe this, I know they're going to sound familiar. Open, notorious, hostile, same thing as adverse, continuous, uninterrupted, and in Illinois, it's 20 years. Kind of sounds familiar. I talked about something like this a few weeks ago. Anybody remember what I said? What kind of using the same terms, number of years? I said it's definitely going to be on a state exam. It was the New York paper guy. You remember my example, the guy walking across the vacant lot to get to his newsstand, and they stopped him from building a property. That was called easement by prescription. Now, the words are the same for easement by prescription and adverse possession. The terms are the same. The number of years is the same, but the difference is in Easement by prescription, you never own the land. Where adverse possession, you actually own that land. You actually own the land. So, let me give you an example of adverse possession. Then I'm going to tell you a true story about adverse possession. And then what I'm going to do is give you a question that you see on a state exam. So here's how adverse possession happens. Let's say a guy from Chicago buys a little cabin on a lake somewhere in rural Wisconsin, and he's going to go fishing there on holidays and weekends and stuff like that. So he bought this cabin, didn't pay a lot of money for it. But every time he drives up to his cabin, he's running into construction and traffic. It takes him forever to get there. He gets out to the cabin and found out that the lake has been fished out, and there's work to be done around the cabin, and didn't pay a lot of money, so he abandons the cabin. Now, for some reason, people in those rural areas know property's abandoned, so they occupy it openly, meaning they park their car right in front of the cabin. They don't park a mile away and sneak in the middle of the night. Notorious, other people are aware that they are occupying property they don't own. Hostile, meaning they don't have permission of the owner. Continuous, uninterrupted, but in Illinois, it's 20 years. So that's just an example. So let me tell you a true story. Someone had a question. We're on, I forgot what page we're on. I want to say, I forgot now. Let me look it up. We are, 163. Thank you, Brian. We're on 163. Now, the hostile means you don't have permission of the owner. That's what the word hostile means. So they didn't give you permission. Okay. Notorious, other people are aware of it, that they know that you're squatting on someone's property. That's right, Sal. Now, so let me tell you a true story that happened. This happened to one of my students, actually. Now, this student, her family was originally from Mississippi, and the family moved to Chicago one by one. You know, the family started gathering in Chicago and stuff like that. And finally, the grandmother came to Chicago, and grandmother been living here in Chicago for many years, and she had a farm in Mississippi. It was a 160-acre farm. It had a farmhouse that they lived in. It had these outbuildings like corn crib and pig house and stuff like that. So there's about 4 or 5 outbuildings. And then the grandmother says, well, the whole family's here in Chicago. I'm just going to sell the property. Call up a real estate agent, find out what the value is. The agent called her back and says, there's someone living on the farm. And they said it belongs to them. Well, the grandmother says, that's crazy. The grandmother was actually born on the farm, right in that house, that farmhouse. It's been 3 generations in that family, been around for about 95 years. It's been in the same family. And now other people are living there. So the grandmother went down there, and sure enough, there's a family living on a farmhouse. And not only are they living in a farmhouse, there was 160 acres of farmland, and they were growing crops on that 160 acres. Well, she called the cops. The law came over, not the cops, the sheriff came over, and said there's no sign of a break-in. This is not criminal. It's a civil matter. You need to go to court. So the grandmother was able to get a court date right away in a couple of weeks. And the grandmother showed up, paying the taxes. She was born there. It's been a family, 3 generations. The other people showed up, and they had the utility bills for the last 5 years. You know what the judge said? New people own that property. And now if they just lived in a farmhouse, that's all they're entitled to. But there was 160 acres of farmland. They had proof for the last 5 years. They bought seed. They planted crops. I think they're growing melons or something like that. They sold the melons. They have proof of everything. And the judge says not only do they own the farmhouse, they own the entire 160 acres and the outbuildings as well. That's what happened. And the reason why Well, in Illinois, it's 20 years. Most of the South, Alabama, Georgia, Florida, Mississippi, it's anywhere from 4 to 6 years. And actually, this is a good law that if you occupy someone's property and make use of it, you actually own it after so many years. Because land is not supposed to be a wasting asset. So if you own land, you have to inspect your property on a regular basis. But if someone goes out there and they start using the land and making a profit off the land, and they do it for a certain number of years, they own that property. So the grandmother lost the property. And she quit paying the taxes, and they had to get the taxes put in their name. They do that by filing what's called a suit for specific performance. Now, so let me give you an example of a state exam question. There is a man, this is word for word on a state exam. A man owns 10 acres of land, and he owns a cabin that's on the land. The owner is confined to a wheelchair. He cannot leave the cabin. He only has one window that looks out the front. Someone occupied the back part of the lot, built a house there, drilled a well for water, lived there for so many years. The question is, does that man own the property? The answer is yes. The other guy owns the property. But the owner's confined to a wheelchair and cannot leave the cabin. And he has no back window, only a front window. Doesn't matter. The new guy owns the land, the part that he's using. He owns it. That's on a state exam, just like that. So just remember, it's 20 years. Well, if someone asks if there's a loan on the land, then what happens is that the owner is the one that signed for the loan, the original owner, and they'll be liable for it. So they could go after the owner's other assets. So notorious says doesn't have to be the owners that know that the property is being occupied. No, it's other people are aware of it. Otherwise, if the owner knew, it would not be hostile. Hostile means they don't have permission of the owner. They're unaware of it. It's other people. Okay. Now, let's talk about transfer of property through a will. One more question. Let me see what it is. That's all questions. Can this apply if someone's renting a home without a lease agreement? Well, if you're renting a home, there's got to be some type of agreement. They don't have to have a lease. They could be paying month to month. It's not a crazy question. So if they're paying it, then they're aware of it. But if you're renting a property, say I rented a house to you, but we're having rent, I'm collecting rent. But if you just occupied my house, see, I can't know about it. It has to be hostile. If you're occupying a house that I own, you've been doing it for 20 years under these conditions, open, notorious, hostile, continuous, uninterrupted. Yeah, you could be the owner of that home. That does happen too. 20 years is a long time. Doesn't happen too often here in Illinois. But in Texas and the South, yeah, it does. It does happen. Now, transfer of property through a will. If a person who dies testate, that means they died and they have a will. And the will is going to dictate what happens to their property. Now, if you die without a will, but you have heirs, you have died intestate. And then every state has a law of distribution and descent, which I'm going to explain to you how the property is going to be divided. Now, if you die without a will, without any heirs, no will, no heirs. And so how did you die? What is that called? No will, no heirs. Escheat. 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 If you die as cheat, real property goes to the county that the property is located. It says, don't forget that as cheat. So let me get to my board and let me write down a couple things to make sure you're clear on these things. Okay. And then erase. There we go. Okay. Test state means that you died and you have a will. And the will dictates what happens to your property. Intestate means that you died, you have no will, but you do have heirs. And then every state, as I said, has a law of distribution and descent as to what happens to your property. So let me give you the examples that you will see. So here's the situation. You died. You're married. And you have children. These are what you will see. What happens to your estate, your spouse will receive half. Your children will receive the other half. If you have one child, they get half. You have 10 children, they're going to share that half equally. So let me give you a state exam question. You died. You're married. You have 3 children. 3 children. After paying off all your debt, there's $300,000 left over. Question is, how much money will the oldest child receive? This is a state exam question. You died. You have no will. Sorry, I forgot to add that in there. No will. You have 3 children. After paying off all your debt, there's $300,000 left over. Question is, how much money will the oldest child receive? Okay. Okay, most of you answer. By the way, when I ask a question, I really expect everyone to answer. For the most part, you're doing good. So, because this is a state exam question, the answer is correct. It's 50,000. 50,000. There's 150,000 that the spouse gets, and the children get 150,000. There are 3. It doesn't matter he's the oldest child or not. They split that equally. So each child gets 50,000. Now, got another question for you. Well, let me explain something to you. Okay. You died. Here's the situation. This is intestate too. You died. You're not married. You have no children. Now what happens to your estate is going to be split evenly among your parents and your siblings, evenly among your parents and your siblings. That's intestate, yes. If, Rebecca, that's if you're married, the one above. If you're married and you have children, so half to the children, half to the spouse. Now again, you died intestate again, but you're not married, you have no children. Now what happens to your estate is going to be divided equally among your parents and your children. So you have, well, let me answer this question before I explain this. No, I don't think so, Ruthie. I think that's could have been on your end, the sound problem. Well, this question is, when does it go to the county? No will, no heirs. No will, no heirs. You have no children, you're not married, but you have siblings and you have parents. So here's the example you'll see on the state exam. So you died. You're not married, you have no children. You are survived by your mother, your father, you have a brother, you have a sister, and another sister. 1, 2, 3, 4, 5. They each get 1/5 of your estate. 1/5, 1/5, 1/5, 1/5, 1/5. If you had a mother and father and you had 6 siblings, 6 and 2 is 8. Then they each get 1/8. It's equally among your parents and your siblings. Now, let's say you had a brother who died before you and he's married and he has children. You know what? He gets nothing. It's the surviving siblings that will share in it. Now, if let's say the mother's deceased, the father now will get the mother's share, which means the father will get 2/5, and each of the siblings each get 1/5. Make sure you know that. So I'm going to give you a question. I'll give you a state exam question. Okay. All right. Here's the question. You died intestate. So what happened? You died. You have no will. You're not married. No children. You are survived by your mother, and a sister. State exam question. What do they each get? You died. You have no will. You're not married. You have no children. You are survived only by your mother and a sister. What did they each get? State exam question. So, let me tell you what the answer is. The first answer you see on the state exam, mother gets half, sister gets half. Wrong answer. The mother will get 2/3 of the estate. The sister will get 1/3. Why? You have a father, a mother, and a sister. 1, 2, 3. 1/3, 1/3, 1/3. Father's gone, mother gets the father's share. This is a question that most people get wrong. Mother will get the father's share. Please make sure you're clear on that. Most of you, more than half of you got it right, so very good. Intestate means you have no will. There's a will that's different. Intestate means you have no will. Question is whether mother and father are divorced. Doesn't make any difference. He's your father. It's okay that you fall for these questions. If you get it wrong, you learn from it. Okay, question is, the previous example, let me go back to it. You have a mother, father, brother, sister, sister. If the two sisters are deceased, no, the brother's only going to get 1/3. You have a mother, father, and brother that's left. As I said, in this situation over here, you have a mother, father, brother, sister, sister. What I said was if you had another brother that died before you did, that brother gets nothing. It's the surviving siblings. The only one that shares in the deceased person is the parents only. Fractions on the exam. Yep. Yes, they are. Here's a question that I have. Now, someone asked, before I ask mine, someone says, whether the mother or father are divorced and a step parent, well, the only way that the step parent will be, stepfather be entitled to it, if he went to court and legally adopted the child, then in the eyes of the law, he is that child's father. Okay, if he legally adopt them, that's what the law says. Now, here's a question for you. What if your mother does not know who your father is? What does the mother get? 2/3 still. Why? You have a father someplace, no one knows where, but you have a father, mother will get 2/3. So, okay, back to our textbook. Make sure you're familiar with these type of examples that you'll see. So let's go to page 164. Okay, a little bit past halfway down, there's a 2-line paragraph. A gift of real property by will is known as the device. The person that receives the property by will is known as the devisee. The next paragraph, you can highlight put X by that one. A gift of personal property by will is known as a legacy or a bequest, and a person that receives personal property by will is known as a legatee or a beneficiary. Now, probate. Now, probate happens, and you can put X by that, if someone disputes the will, or there's several different wills, then the courts have to decide which will is legitimate. Now, or someone could contest the will. Now, let's say that you have 2 children. You're the only parent surviving, and one child is always there and supports you and everything else and tends to whatever you need, and the other child's complete bust out. And so you have $1 million and you created a will and you left $1 million to your one child and you left nothing to the other. Now, the child that did not receive anything at all, they weren't included in the will, they could go to court and probably file during probate and said that I don't know what happened. My parent forgot about me and will probably receive half the estate. Now, if you don't want someone, a relative of yours, to get anything, you do include them in a will. You just give them $1. I'm going to give $1 million to one child and $1 to the other. That tells the court, I didn't forget them, but this is what I think of them. And they will not be able to contest the will. So leave them $1. Yes, Rebecca, that's right. You're absolutely right. Now, let's go on to the next page. Here's something. In the middle of the page, there's 3 bullets, but put an X by the second bullet. You cannot disinherit a spouse. You cannot disinherit a spouse. So if you try to disinherit a spouse, that second bullet, the spouse will be entitled to 1/3 of the estate and 1/3 of each parcel of real estate. That's an exam question. Actually, it's also in the back of this book. So this other stuff I already covered. Let's go on to real estate documents, public records, okay? I'd like you to highlight, put an X by that. Public records contain detailed information of each parcel of real estate in the city or the county. These records are crucial in establishing ownership, giving notices of encumbrances, and establishing priority of liens. They protect the interests of real estate owners, taxing bodies, creditors, and the general public. Now, let's skip down a few paragraphs where it says, public records are just that, open to the public. I like to put an X by that one. Anyone that has an interest in a particular property could go down to the county, search the public records to see who has an interest in that property, if there's any liens on that property. Now, recording, I like to put X by that one. Recording is the act of placing documents in the public records. Any written document that affects the estate, right, title, or interest in land must be recorded in the county where the land is located to serve as public notice. Now, the next line all by itself where it says Illinois law. Illinois law does not require that most documents be filed or recorded within a specified period of time. However, in Illinois, when creditors and subsequent purchasers do not actually know the content of the documents affecting certain real estate interests, the courts will hold these creditors and purchasers responsible for discovering and knowing that information only at the date that the documents are recorded. Let me give you an example. I own a home, and you lent me $50,000, and I wrote a note, had it notarized and everything else, and I'm going to pay you the $50,000 when I sell the home. So I gave you this document here. I will pay you when I sell the property. Well, what happened is you did not record that document. And I sold the home and I didn't pay you your $50,000. You can't go to that new owner and says, hey, look, here's a document. Sam said he's going to pay me $50,000 once he sold the home, and he didn't pay me. I want my money. Well, that new owner is going to say, you know what? You got a problem. Go and see Sam. It was not recorded. The new owner is not responsible for it. Okay. Let's go on to constructive notice towards the bottom of this page. I want you to highlight, put an X by constructive notice, highlight, put an X by actual notice. Now, constructive notice is notice to the entire world. I have a deed right here in my hand. I signed this deed over to you. And you took this deed and you recorded the deed. By you recording the deed, you told everyone in the world you own that property. Because anyone could search the public records. Very strong. Notice to the entire world. Very powerful constructive notice. Now, I got a deed here in my hand. I took this deed and I gave it to one of you. And you did not record it. Well, you got witnesses. You got 24 witnesses that saw me give you this deed. And you try to sell this property 10 years from now. Remember, you never recorded the deed. You might have a hard time trying to sell that property. You're going to have to get affidavits from the other students that saw me on this date give you this deed, because you could have broken into my home and stolen this thing out of my home. You could have maybe I dropped it outside and you picked it up or something. So actual notice is just an eyewitness. It's very, very weak. Constructive notice is notice to the world. By you taking this document and filing this, then you told everyone in the world your interest in this property. All right, next page. A couple paragraphs down. Unrecorded documents, you can highlight, put an X by that one. There are certain documents that do not need to be recorded to be valid. Property taxes. Property taxes automatically become a lien on January 1st of any given year, even though they're not due and payable to the following year. Property taxes. You skip down 2 paragraphs where it says chain of title. Now, a chain of title is a record of the property's ownership, beginning with the earliest owners. The title passes to many individuals. Each owner is linked to the next, so a chain is formed. This is what you want to buy when you buy property. This is called clear title. I'm going to give you an example in a moment. This next paragraph, highlight, put X by as well. If ownership cannot be traced to an unbroken chain, there's a gap or a cloud in title. And then you have to get a court action called a suit to quiet title. So let me explain both of these to you. Chain of title. Now, when you buy property, you want to make sure you get clear title to the property. So what happens? A is the original owner. A got this property. Owner A got it from the government. So owner A sold it to owner B. Owner B sold it to owner C. Owner C sold it to owner D. Owner D sold it to owner E. And here you are buying this property from E. What we have here, that every owner is linked to the next, where they form this chain. And this is what you want when you buy property. This is called clear title to property. Now, let's say owner A got the property from the government. Owner A sold it to owner B. Owner B sold it to owner C. Owner C sold it to owner D. And then here you are buying this property from owner E. But we got a problem here. We don't have a connection from D to E. What we have here, we have a gap in a chain of title. You do not want to buy this property from E until this could be cleared up. Now, it could be this. Maybe D died and E inherited the property. Then all E needs to do is bring a copy of the death certificate and a copy of the will. And that would clear up that cloud on title or the gap in the chain of title. Maybe it's something more simple than that. Here's what happened. D got married, changed her name to E. That could be cleared up. Usually with you bring the marriage certificate that's recorded with the county and certified and recorded with the county. And then they file a quitclaim deed. Maybe E acquired a property through adverse possession. All E has to do is file a suit to quiet title, and that will clear it up. But until that's cleared up, you do not want to buy this property from owner E. You do not. Now, title search and abstract of title. Can highlight, put X by that one. A title search is the examination of all the public records to determine if there's any defects that exist in a chain of title. Now, normally in this country, they go back around 40 years. Now, that next paragraph, for some reason, in Cook County, especially Chicago, they go back approximately, well, minimum 75 years. Is not unusual to go back 100 years, even over 100 years in the Chicagoland area. I don't know if people keep their properties longer or anything else like that. I'm not sure. I bought my house when I bought my first home in Chicago. It was on a far northwest side, kind of like where Niles, Lincolnwood, Skokie, they all kind of met that part of Chicago that surrounded that part of Chicago. It was called Edgebrook area, Wildwood Edgebrook. And when I bought the house in 1981, I was the third owner. The owner before me who bought it, well, actually, I was the fourth owner. I was the fourth. The third owner was a judge who bought it from the second owner, who was a movie producer, who bought it from the original owner, whose name was Chief Billy Caldwell of the Potawatomi Indians. All that land up there, right off of Caldwell and Devon and everything else, it's all owned by Chief Billy Caldwell of the Potawatomi Indians. My house was the third home built out in that area. And actually, my documents, and I believe I still have on my title report, list Chief Billy Caldwell as the previous owner of the property. So, who actually kind of stole the land from the tribe. He was supposed to split it with the tribe, but he kept it all. He actually did. And this is Chicago. You might expect it in Wyoming or Colorado, but Chicago, you don't see too many Native American tribes that still own the property that's going to show up on a title, but mine did. So they go back pretty far in the Chicagoland area. So mostly like Indian named streets up in that neighborhood up there. Let's go on to the next paragraph. Highlight, put an X by that, 2 paragraphs down. An abstract of title is a summary report of what the title search found in the public records. So the abstract of searches of public records summarizes the various events and proceedings that affect the title throughout its history. Skip down to let's go on to the next page. Would title search identify a gap in a chain of title? Usually it will, because it lists all the previous owners. Yes, it will. Now, there's something else. I should have explained this to you. I didn't. Title insurance, well, when someone buys a home, they have to get homeowners insurance in case a house burns down or maybe someone falls down the steps. That's homeowners insurance. Title insurance protects against defects in the title. Now, title insurance, marketable title. This is near the top of 169. Marketable title. I like you to highlight, put X by the next 3 bullets. Under the terms of a typical real estate sales contract, it says the seller is required to deliver a marketable title to the buyer. At the closing, to be marketable, a title must, and these 3 bullets, as I told you, put an X by, disclose no serious defects, not depend on doubtful question of law or fact to prove its validity. Next bullet, not expose the purchaser to the hazard of litigation. And then the 3rd bullet, convince a reasonably well-informed, prudent purchaser acting on business principles that they could sell or mortgage a property at a later time. Proof of insurance, highlight, put an X by that. Proof of insurance is evidence that the title is marketable. A deed is not sufficient proof of ownership in Illinois. It has to be backed up by title insurance. A certificate of title, highlight, put an X by that one. Now, a certificate of title is a statement of opinion regarding the title status. What happens at the closing, usually it's a lawyer. They pick up the title report. It's about 10, 12 pages long. They look at it. They go, yes, property taxes have been paid. They check it off. This lien has been paid. The affidavit that the names are correct, the owners are correct. So they check off all these things, and then they give their opinion. They issue a certificate of title. Now, who could issue a certificate of title? Well, a title abstract or an attorney or a title company. Now, it's 2 paragraphs down, abstract and attorney's opinion of title. Again, once they run the title report, someone has to give their opinion whether or not the title is good. Again, a title abstractor could give their opinion, an attorney could give their opinion, and a title company give their opinion. Let me ask you something. What do you think the opinion of a real estate agent means? Nothing. Your opinion means absolutely nothing. Now, title insurance. This next paragraph on the next page, put X by it. Title insurance is a contract. It's an insurance policy that protects against defects, in which the policyholder, the buyer, is protected from any losses arising from defects of the title. Who pays for the title insurance? Seller pays for the title insurance. Who's protected? The buyer's protected until the property is transferred. Now, skip down a couple of paragraphs after the set of bullets. The premium for the policy is paid at once at the closing by the seller. You can put an X by that, the first line. The premium for the policy is paid once at the closing. Seller pays for it, the buyer's protected. In fact, the next paragraph, you can highlight, put an X by it. A title insurance policy is most commonly used evidence as assurance that the owner of real estate property tenders to a prospective purchaser or lender as proof of good title. The seller, again, has to prove it's theirs and they have a right to sell. Now, let's skip down to the towards the very bottom, last two paragraphs, highlight, put X's by it. Now, owner titles insurance policy, the coverage. Exactly which defects in the title that the title company would defend depends on the type of policy. Most people get the standard coverage policy, and this protects against things like forged documents, conveyances by incompetent grantors, incorrect marital statements, improperly delivered deeds. Now, there is a extended coverage, which is the last paragraph. We'll put an X by this. This is called the ALTA policy. ALTA stands for American Land Title Association. A lot of you will see the words ALTA. So now the ALTA policy has everything in a standard policy, but it has additional protection, which might be on the next page. Yep, rights of parties in possession, certain unrecorded liens, examination of survey, things like that. Now, again, remember this. A deed is not proof of ownership. A deed is a piece of paper that transfers ownership. Proof of ownership, title insurance is proof of ownership. ALTA is proof of ownership. And a attorney or abstractor's opinion of title is proof of ownership. A deed is not proof of ownership. Now, last couple of paragraphs of this chapter here, they talk about the lender's policy. Now, the seller needs to pay for title insurance to protect the buyer. And this could cost around $2,000. Now, the lenders want protection for the loan amount. And who pays for that? The buyer pays for that. But it's a endorsed copy, whereas the seller pays $2,000 for title insurance. It costs the buyer about $350. So remember this. Seller buys title insurance to protect the buyer. Buyer pays title insurance to protect the lender. But it's only a fraction of the cost that the buyer pays for, because all it is a endorsed copy. That's the end of chapter 9.